Okay, Law 30 students, today, or in this particular presentation, going to go away from the voice thread and do a screencast instead, because I want to talk about sources of law, and it's a little bit more involved, and there's a few more notes here to put on a voice thread. So if you can just follow along here, this is in your law text, and I'll also cut and paste this so that you have a set of PDF notes that deal specifically with sources of law. Now, again, just to maybe avoid some confusion, you are not required, or as of yet, you have not been required to submit any assignments. And what I'm trying to do is to cut down on the number of written assignments that you do in Law 30. And in fact, I'm going to try and make sure that you're basically just learning the material and having access to quizzes. And that's how I'm going to test your knowledge, is basically through the quizzes and the tests. So you've had one quiz till this point. You have not had anything else that you've needed to hand in. I have asked you to contribute to some of the forums, or some of the forum questions that you may have come across. So let's take a look at sources of law. So it says among the factors serving as traditional sources of law in Canadian society are, so these are traditional sources of Canadian law: religion, customs, conventions, social and political philosophy, and history. So all of those have an impact on our Canadian legal system and can be considered sources of our law. So, and they would be considered traditional sources. So going back quite a ways, in fact. So additional sources of law, and these would be very current sources of law, would be our Constitution. Okay, and that includes the Charter of Rights and Freedoms. Treaties. We've discussed a little bit about the treaties with the First Nations people. Written statutes, and we've talked about how a statute becomes a statute, and a bill and a law, and the difference between those two. And court decisions also are sources of law, and we know that from our knowledge of the way a common law system works, or the English common law system works. So what makes this particular section fairly involved is the whole Charter of Rights and Freedoms, and I want to spend a little bit of time on that. All right, so just to talk a little bit about the Canadian Charter of Rights and Freedoms, it says in Canada, both federal and provincial or territorial governments protect the individual rights and individuals' rights and freedoms. The territorial governments may also legislate to protect human rights, since the federal government has delegated those powers to them. So just a little bit of history about the Charter. So the Canadian Bill of Rights was passed in 1960, and it was the first law that specifically set out fundamental human rights for Canadians. The Canadian Human Rights Act, first enacted in 1977, also protects human rights, particularly in the areas of employment, housing, and commercial premises. Unlike the Canadian Bill of Rights, the Canadian Human Rights Act applies not only to the federal government but also to the private sector in matters that are regulated directly by the federal government, such as banking. So all provinces and territories also have human rights legislation, and that would include our province as well. And this is to prohibit discrimination on various grounds with regard to employment and provision of goods, services, and facilities. So the Quebec Charter of Human Rights and Freedoms, passed in 1975, protects all fundamental human rights, as well as some political, social, and economic rights. Now, in our province, in Saskatchewan and Alberta, they enacted Bill of Rights in 1947 and 1972, respectively. So ours in 1947, Alberta's in 1972. This legislation applies to discrimination by both individuals in the private sector and by provincial and or territorial governments. Now, this paragraph is quite important here. It says, nevertheless, the protection by all of that legislation is limited. So all of those various acts of legislation that attempted to define and protect individual rights, it was limited. Why? Because the Canadian Bill of Rights, the Canadian Human Rights Act, and all of the provincial human rights codes are just that. They're legislation. So if you remember what legislation is, it's a bill that gets passed that ends up getting royal assent, and that becomes law. However, it's also possible to repeal them by the exact same process. So, it was not until the advent of the Canadian Charter of Rights and Freedoms that human rights in Canada were protected in the Constitution. So I can't say enough how important this is. Before the Canadian Charter of Rights and Freedoms, yes, individuals had rights, they had freedoms that were outlined in various uh, pieces of legislation. But if you remember how legislation becomes legislation, you would understand that if it's legislation, it can also be repealed, or other pieces of legislation can be enacted to reverse um, what was already legislated on. Okay, so this way, the Canadian Charter of Rights and Freedoms, it protects it in our Constitution. So this one, the next one, it says the role of the Canadian Charter of Rights and Freedoms. When the Constitution was patriated in 1982, now what this means by being patriated is that prior to 1982, our Constitution, anytime we wanted to make changes to it, we would have to get the consent of the British Parliament. So here it was a long time after Canada had been its own country, where we'd fought in world wars, had a significant impact on the world scene, and so on. And yet, any time we wanted to deal anything with our own constitution, we'd have to go back to Great Britain and get an act of the British Parliament to be able to change our own constitution. And that was just a little bit awkward. So, in 1982, we went through the process of patriating our constitution. That basically means that we brought it home. So that we would be able to, in our own parliament, be able to make changes to our own constitution without having to go to Great Britain and going to the British Parliament. So the Canadian Charter of Rights and Freedoms at this point became a fundamental part of our Constitution. So at the same time it was patriated, we also had the Canadian Charter of Rights and Freedoms that became part of our Constitution. So it says the Charter takes precedence over other legislation because it is entrenched. So that means it trumps other legislation. And why? Because it's in our Constitution, which is the supreme law of Canada. So it applies all over to all jurisdictions, so to provincial legislatures as well as Parliament. So this means that when an individual who believes that Parliament or a legislature has violated guaranteed right asks the courts for help, the courts may declare the law invalid as far as it conflicts with the Charter. In addition, courts may provide other appropriate remedies to individuals whose rights have been violated or infringed. So that means that basically if you have a case that certain laws are infringing upon your guaranteed rights in the Charter of Rights and Freedoms, you have an avenue, which would be the Supreme Court of Canada, to be able to decide whether or not your individual freedoms are in fact being violated. And if so, the laws that have been enacted that actually do infringe can be repealed. Alright, so just to give you an example off the top of my head, let's say you had a particular form of freedom of speech, and let's say you wanted to say that I don't know, every school should be painted blue. Just for an idiotic example, every school should be painted blue. And let's for some reason say that a school board, which is actually a form of municipal government, enacted or passed a policy that said we're not painting our schools blue. And you can't talk about painting our schools blue. Well, you could actually ask the courts to decide whether or not that legislation violates your fundamental freedom of free speech. And if the courts actually decided that it was in violation of your freedom of speech, then the school board would actually have to repeal that law. It would be invalid. And that's what this section is actually talking about. So it says, however, the Charter also recognizes that even in a democracy, rights and freedoms are not absolute. So you do not necessarily and unilaterally have rights just absolutely. For example, or for instance, freedom of expression is guaranteed, but no one is free to yell fire in a crowded theater. So that means you can't you can't do something like yell fire in a crowded theater and expect the Canadian Charter of Rights and Freedoms to protect those rights. It doesn't work that way. Um, you're not allowed to slander someone or to spread hate propaganda, so you can't use freedom of speech as a basis to spread hate. Therefore, Parliament or provincial legislature can limit fundamental rights, but only if that government can show that that limit is reasonable and is prescribed by law and can be justified in a free and democratic society. In other words, if a government is going to limit your freedoms, it has to be reasonable, it has to be prescribed by law, and it has to be justifiable. So the interests of society must be balanced against the interests of individuals. So in that case, yelling fire in a crowded theater, there is an issue there of balancing your right to free speech to everyone else's right to enjoy safety in a theater without being antagonized or scared or so on. The Constitution affirms that we are a multicultural society and that the Charter rights must be interpreted consistently. So our Constitution actually says that we are a multicultural country. Okay, under the agreement between the federal and provincial governments that resulted in the Constitution Act, both Parliament and the provincial legislatures keep some limited power to pass laws that may violate Charter rights. This is democratic because it gives elected legislatures the last word. However, their power is still limited because Parliament or provincial legislature must specifically declare that it is passing a law notwithstanding specified provisions of the Charter. And they will refer to this as a notwithstanding clause sometimes. So this declaration must be reviewed and be reenacted at least every 5 years, or it will not remain in force. These limits act as a kind of warning to the Canadians and force the government to explain itself, to accept full responsibility for its actions, and to take the political consequences. So what this is saying is that there are limited times where a government, through a notwithstanding clause, can actually violate a fundamental freedom. But it has to explain itself, and if it can't, that does not last for a period longer than 5 years. So what are the rights that the Charter protects? So the Charter protects fundamental freedoms, democratic rights, the right to move from one province or territory to another in Canada, legal equality, language rights, and Aboriginal rights. So these would be fundamental freedoms that the Charter protects. So for instance, everyone in Canada has a right to practice any religion. The freedom of the media to print and broadcast news. All of these are fundamental freedoms. Democratic rights. So Canadians have a constitutional right to vote. That would be a democratic right. There would be, the Charter requires governments to call an election at least once every 5 years. Okay, and so on. So these would be considered democratic rights. Mobility rights are basically, it's a charter right, meaning it's in our Constitution so that you can enter, remain, or leave the country, and you have the right to move within any jurisdiction in Canada without any issue or any problem. Legal rights. So the Charter provides for individual or protects the individual and ensures fairness during legal proceedings. So it defines what legal rights you have. The Charter also protects against arbitrary action by law enforcement agencies. It guarantees our rights to be told why we're being arrested or detained, to consult a lawyer without delay, and so on. If you're charged with an offense, you also have the right to the following. Okay, to be told promptly of the offense, to be tried within a reasonable time, and so on.